Texas Governor Greg Abbott signed a bill into law banning most abortions as early as 6 weeks and allowing
to pass a bill that I'm about to sign that ensures that the life of every unborn child who has a heartbeat will be saved from the ravages of abortion.
Law is not law if it violates the principles of eternal justice. Starting with the quote, "This Women's Day, let us talk about one of the most debated and restrictive laws enforced last year, which has attracted concerns of women, human rights activists, and citizens of not just USA but from the world, the Heartbeat Law of Texas. Senate Bill 8, also known as the Heartbeat Law, is USA's most restrictive abortion law established in Texas. It was introduced as Senate Bill 8 and House Bill 1515 on March 11, 2021 and was signed into law by Governor Greg Abbott on May 19, 2021. The law came into effect on 1 September 2021 and states that a physician may not knowingly perform or induce an abortion on a pregnant woman if the physician detected a fetal heartbeat for the unborn child. The Justice Department filed its lawsuit against Texas in September, arguing that Senate Bill 8 is unconstitutional. It says the bill violates the Supremacy Clause as well as the equal protection afforded under the 14th Amendment. It also says that the law violates U.S. Supreme Court precedent. The U.S. District Court Judge Robert Pittman said that from the moment Senate Bill 8 went into effect, women have been unlawfully prevented from exercising control over their lives in the ways that are protected by the Constitution. He also added, other courts may find a way to avoid this conclusion is theirs to decide. This court will not sanction one more day of this offensive deprivation of such an important right. U.S. Attorney General Merrick Garland called the court's decision a victory for women in Texas and for the rule of law. However, the law was re-established by a federal appeals court days after the lower court suspended the Republican-backed law. Now talking about the Heartbeat Law in detail, it is a law which bans almost all types of abortions after 6 weeks of pregnancy, a period when cardiac activity or heartbeat can be first detected in a fetus. The law does not make any exceptions to rape or incest, but very narrow exceptions in case of health issues, allowing a termination only if the pregnancy could endanger the mother's life or lead to substantial and irreversible impairment or damage of a major bodily function. The law also allows private citizens to sue abortion providers and anyone else who helps a woman obtain an abortion, including those who give a woman right to a clinic or provide financial assistance to get an abortion. Private citizens who bring in these suits don't need to show any connection to those they are suing, and in fact anyone who successfully sues an abortion provider under this law could be awarded at least $10,000. For this, the Texas Right to Life has also set up what it calls as a whistleblower website where people can submit anonymous tips about anyone they believe to be violating the law. Other states including Georgia, Mississippi, Kentucky and Ohio have also passed heartbeat laws that ban abortions when cardiac activity or heartbeat can be detected on an ultrasound scan. Those laws would also ban abortions at about 6 weeks of pregnancy, 18 weeks earlier than the legal standard set by the Roe versus Wade case, which allows abortions up until 24 weeks, roughly the point when a fetus can survive outside the womb. But those state laws have been held up by legal challenges and have not been implemented. Citizens and medical practitioners point out some serious flaws in the law, such as banning abortion after 6 weeks. They argue that 6 weeks is a very early time period for women to be aware of their pregnancy. By the time a woman misses her first monthly cycle, she is already 4 weeks pregnant. So, if her cycle delays, she'll have only 2 weeks to get a pregnancy test done and decide about the continuation of her pregnancy, which may not be possible because for this, one needs to have at least regular menstrual cycle. Moreover, a woman may not actually be pregnant in case she misses her cycle. There are various reasons such as stress, tension, workload, or other health issues such as PCOS, PCOD, which impacts monthly cycles. Hence, 6 weeks is not a sufficient time frame to decide for pregnancy or abortion. Also, doctors pointed out that heartbeat detected at 6 weeks is not an actual heartbeat, but beginning of formation of heart valves. Actual heartbeat is produced only after 8 to 10 weeks. Now talking about the criticisms of the law. The abortion providers in Texas estimated that 85% of patients seeking abortion are at least 6 weeks pregnant and would be denied care under the new state law. The law will create nearly insurmountable obstacles for certain vulnerable populations, such as women of color, who accounted for 70% of abortions in Texas in 2019, black women, low-income women, undocumented women who cannot travel easily around the state to get access to the health care, women with chronic illnesses, and teenagers who often don't realize they are pregnant until later in a pregnancy. Texas also requires minors to obtain permission from a parent or guardian to gain access to the abortion care. Some minors must go to the court to do so, adding to the delays. The law shows no mercy towards the rape victims as well. If a young woman becomes pregnant as a result of sexual assault and is given information about how to obtain an abortion by a counselor, the attacker has the right to sue the counselor or provider, leading to foolproofing of crime rather than providing justice. Moreover, the law also violates women's rights over her own body, right to abortion, etc. Finally, moving towards a Q&A section with the experts. Today, we'll be talking with Ms. Ridambara Das about the heartbeat law.
Hello everyone, my name is Ridambara and I'm an assistant professor. My area of specialization is human rights. I teach at the Symbiosis Law School, Pune as a visiting faculty and also a couple of other places. And I'm also associated with the Women Rights Organization in Pune.
The law violates women's rights. But do you think the law directly or indirectly would also violate child rights such as right to be born well, right to basic needs, right to access what they need to have a good life? What are your opinions?
With regard to your question 1, of course it violates or it at least has the potential to violate your most basic rights of the child. And the only way, the best way to understand this is to first understand how this violates the rights of a woman. Now think of it this way, that abortion is an option available for all women. There are some women who absolutely do not want that option. They are not going to even exercise that, not even that thought, because they are more than willing to carry this pregnancy out. It was planned, it is what they wanted, and even if it was not planned, it's something that they want to do it. So they are a category of persons who really want to see this entire thing through. But abortion is sought by women who are either victims of a crime or their body does not medically permit, or it puts them at some sort of risk, and therefore they are contemplating this as an option. So we are already looking at a set of women who for whatever reasons do not want to carry this pregnancy through. Now this is not obviously an obvious and a direct result that I don't want it and therefore 100% I know for sure that when a child is born I'm not going to look after it. But we have to take this into consideration that there is a very good chance if you are forcing me to carry through this pregnancy, once I'm done with it, I may not want anything to do with that child. And then who takes responsibility of that child? What about the right to well-being? What about the right to life? Adequate standard of livelihood, where that child needs to be provided for emotionally, financially, and through basic needs like food, shelter, water. So what if when you force somebody to go through the pregnancy, and after that if that mother decides to put the child up in foster care or just abandon the family or the child and go, who is going to then look after this child, and how much is the state going to take responsibility? There is going to be a time when they run out of resources. So what kind of future are we looking at when we can't secure the future of your child? then what is the point of this? Where is the right of child that is being discussed? Lastly, you are forcing people to not avail the right of an abortion. Are you now going to force them to look after their children forcefully? Is this how this is going to work? Where you keep on forcing individuals, human beings, adults to act in a particular manner? This can't be the way, this can't be the best way at least.
John Ciego, the legislative director of Texas Right to Life, justified the lawsuits as not being against women but process of money making from abortion. Do you think there could be any political agenda behind the law, especially entitling private individuals with suing rights?
With regard to your second question about what is its political motivation, now based on, we all know that politics works on ideologies, and religion and politics play a very strong role in policy making, but that is really not the point. The point is, if your argument is that this is not about the right of women, but it is about ensuring that there are no medical extra expenses, no one's ripping you off, doctors are not cheating you, then this point can completely be countered, that because we know for a fact that wherever abortion is denied, there is an entire different set of methods that are adopted, which we call unsafe practices, or for that matter will open up like the black market for it, where people are doing it on the sly, where you'll be paying an insane amount of more money because of the risks involved, and a woman will be willing to go to any extent, and there are serious consequences for that, because if she doesn't have the adequate amount of money, she'll have to do certain things to get that money. You're putting people in an extremely vulnerable position, and then you're doing it on the sly, so there are no rules, regulations here, there is nothing to keep a check. And not to mention the problem of unsafe abortion, which actually eventually could also lead to the death of the woman. So this cannot possibly be a reasoning that we don't want, we're trying to control doctors who unnecessarily provide abortion. A woman who does not want an abortion is not even going to ask for it. So the ones who are seeking it are the ones who want it. So where's the question of stopping doctors? And this part where this law is highly problematic is that it gives individuals the right to draw out a case or to sue a doctor or a hospital or any other organization that is providing for abortion. Now this is dangerous on multiple levels. First of all, no law, except for public interest litigations, law does not permit any random person who does not have an interest in the matter to even file a case. So this is giving extensive power to a private citizen. And mind you, that private citizen is probably going to get to know it only if he somehow gets to breach your privacy. Because how else is that citizen getting information about who's getting an abortion and where are they getting an abortion, etc. So there's going to be a lot of moral policing, there's going to be a lot of citizen-based policing, which will also lead to various other violations. And because of that, it's going to actually open up a black market. There's going to be unsafe abortion, there's going to be moral policing by citizens, and human rights does not really allow for you to control somebody else's rights. It is your religious belief. Please go ahead and respect your religious beliefs by not availing of something that you believe is a sin. That's perfectly fine, and that's your human right. But you can't force it on another person simply because it doesn't suit you. That's a violation of their rights. So politics aside, whether it is politically motivated or not and it's playing to the galleries is hardly a concern for us.
Do you think such laws should only remain as a matter of state concern, or international organizations such as UN should intervene even without state consent?
No, every sovereign state has the right to make laws based on their constitution, and of course keeping in mind their international treaties, their international obligations and human rights. So of course primary responsibility is with the state. Now having said that, It doesn't mean that other organizations, other countries, and other international organizations or NGOs cannot take this issue up. But you cannot intervene in inverted commas. You can you can make criticisms, you can write about it, you can put international pressure, you can, when a discussion in the UN happens, or let's say the Human Rights Committee makes a general recommendation upon the request of somebody else, they can make general recommendations, they can make comments, they can discuss the issue in the General Assembly. That is putting enough political pressure on a state to rethink its stance. But the primary responsibility and primary onus is based out of your constitution and lies with the state itself. So eventually it is the United States of America that is going to have to strike this law down if it believes it to be unconstitutional based out of its existing constitution. And what the international world community can do is to highlight how this law violates its constitution, how it violates every standard international human rights document that we have, and by whatever chance, if somehow the Supreme Court of the US decides that this law is not unconstitutional, then the international community can put enough pressure on the government to rethink its constitution, rethink its laws.
Do you think this law may make people conservative and cautious about their reproductive health, as it is observed that the number of abortions has declined since the uphold of the law?
Regarding the last question, look, laws don't exactly have this kind of an effect on people, at least instantly. But what law instantly can do is put fear. Now, fear is not exactly the best teacher. So you are not going to be able to make me more cautious or conservative about my sexual choices. You are going to be putting the fear that I know that I'm not going to be able to get an abortion after 6 weeks in any hospital in any legal manner. So then I'm scared, because what if I get pregnant and then what do I do? Now please understand that pregnancy happens, it can happen by accident. When it happens by choice, those are the kind of people, unless there is a complication, they are not the ones who are going to opt for an abortion. So abortion is sought by those people who had an unplanned pregnancy and who are victims of something or medically cannot carry out the pregnancy. So they have other reasons why they want to have the abortion. So having a law like this is not really going to change my behavior, because I anyway do not want to get pregnant. So I am anyway taking the maximum precautions that I could possibly take at that moment. Okay, a little bit of rash behavior maybe can come down, but in light of these few numbers reducing, putting all women at risk of going through unsafe abortions or going through a process where there is no legal regulation is not worth it. So whether it makes us more aware is not actually as beneficial as the harm this law is doing to people and the future of children also when they are born. So in effect, and as far as conservation, becoming conservative is, then I don't think that's going to happen, because people do what they want to do at the end of the day. And if laws could control how conservative or how liberal I am to be, then all of us would have been acting in the same manner. So law is not made with the idea, or should not be made with the idea of making people conservative or liberal. That you can have your own set of beliefs and follow it accordingly, which is what actually happens. So in effect, this law is not really going to change people's behavior pattern. It is only going to instill fear, and once you find yourself in a difficult position, you are going to figure out very dangerous ways to be able to solve your problem, and that is putting you outside the legal purview, which makes everything very, very dangerous.
Talking about the updates, meanwhile, debates are still going on for the heartbeat law. On 2nd December 2021, the Texas government signed Senate Bill 4, which restricts the use of abortion-inducing drugs. Mississippi's Dobbs versus Jackson Women's Health Organization case will determine the future of Roe versus Wade. If Roe versus Wade is overturned, 12 more trigger states will adopt stringent abortion laws. Ohio lawmakers have also introduced HB 480, a ban which mimics Texas law but is far stricter. Florida House has also passed an abortion law banning abortion after 15 weeks, that is 4 weeks earlier than the Roe versus Wade. So now, finally concluding by asking our expert one of the most crucial questions. With the uphold of the heartbeat law in Texas, many more trigger states are now implementing the abortion laws, which are even stricter than the Texas law. So what would be the future of Roe versus Wade in USA?
So the last question is, what is the future of the particular case Roe versus Wade in the US, given the Texas law and now the Mississippi law and a lot of other states that are talking about creating state laws to ban or restrict abortion. So essentially the Roe versus Wade laid to rest the stance of the US with regard to abortion, whereby they guaranteed or women had this guaranteed right to access to abortion up to 24 weeks. Now this case is almost 50 years old. So for 50 years women have been guaranteed this right, which now these state laws are challenging, and the Mississippi law has been taken up in the court and the final judgment is awaited, but one does have an apprehension or one has an indication that the court is going to uphold the Mississippi law, which in effect means that it's going to actually overrule or change at least to a certain extent the Roe versus Wade judgment. So because the Mississippi law talks about giving granting of abortion up to 15 weeks, while Roe versus Wade allowed for abortion up to 24 weeks. Now what is the result of this going to be? One, that if the court actually does allow for state laws like this, it will nullify or alter Roe versus Wade. And what effect will that have? Essentially, that just means that women are going to go back 50 years into what they used to be. One of the arguments placed in while hearing the Mississippi law case was that 50 years back women needed that kind of special protection and assistance, but in today's time women are far more empowered and women have better family care and are going to be in a better position to juggle their family life and career life. Now this argument is very flawed because statistics, if you look at it through statistics, there is nothing to really put such a statement to effect. And given that we are in a better position because we have special protection laws, are we going to remain in this better position if you remove the special protection? Then probably not. So removing this kind of a guarantee of abortion is going to actually just push us back 50 years. It's not like it's going to keep us where we were with this law in 2022. So that's number one. Number two, to suggest that women are in a better position to handle their career and their family life is actually stepping on our rights as women, because simply because there is a difference between giving birth and parenting. There is a difference between choice and compulsion. I may not want to have the child. It is not really, every question does not start and end with whether I can do it or I can't do it. It also entails whether I want to do it. So whether you are helping me or not helping me, or whether my life is in a better position, that was not the reason why women wanted abortions only, that because I can't look after the child or I have to either settle for a family life or a career life, and now given that we can do both, nobody would want an abortion. That is a very ridiculous sort of an assumption to make. And the second argument placed was that if you go through the pregnancy and you don't want the child, you can give it up for adoption. That is a very, very hypothetical and an improbable sort of a solution to give someone. It's a very emotional and physical process of giving birth to a child. You are literally putting a human being for no fault of theirs in a very, very emotionally churning turmoil, where at the end of it you would be torn between your sense of ethics, sense of motherhood, sense of everything that would come attached, and a sense of attachment that you have to something that you gave birth to. And in effect, you may not end up being able to actually give up your child for adoption. Or what if no one takes your child up for adoption? Then the child will go into foster care. That puts an unnecessary burden on the state, which in effect will create a collapse in the system of foster care. And the US foster care is not one to boast of. We know of instances where children have been subject to all kinds of abuse. So you know that the future of the child is uncertain. How can you promote such a suggestion? So in effect, this is literally the Mississippi law is doing nothing but furthering the stripping of the right of women to choose. And it is true that there is on the one side the rights of child, and on the other there is the right of the mother, or right of women, and you can in this case only choose one. But there is no real justification to take away this right from a mother, or take away this right from a woman, the free choice that she has whether or not she wants to carry out this pregnancy, whatever may her circumstances be. So in conclusion, all I would like to say is that the US looks like it's heading towards a very dangerous sort of a precedent, where a guaranteed right over the last 50 years is appearing to be wading off, or in a certain way it's no longer going to be effective unless and until their Congress passes a law, a federal law, that actually puts to rest this judgment, Roe versus Wade. So instead of constantly depending on the court to come up with different ways of either striking down a law or not, and allowing states to make laws of their own, which is something that this case is looking to achieve, it would be easier if once and for all there is a federal law that says that protects the right of abortion for women, so that we do not have to face this today or any time in the future. Thank you.